各位議員，我哋
Good afternoon, members. We have already reached the scheduled time to start. We've also formed a quorum. I declare the meeting open. Members, please return to your seat. Please stop shouting within the conference room so that we can conduct the meeting smoothly. Members, please return to your seat. Members, please return to your seat so that we can start our meeting. Members, please return to your seat so that we can hold our meeting. Item 1 on the agenda. Confirmation of verbatim transcript of meeting. Verbatim transcript of the 23rd meeting held on the 17th of May 2019. Prior to the meeting, I have received 10 plus members writing in to propose amendments and suggestions to the transcript. I have already referred the written opinions as well as the proposed amendments to the professionals of our Translation and Interpretation Division so that they will check against the audio recording as well as the webcast. We'll wait for their reply, and then the relevant transcript, the verbatim transcript, will be referred to members to consider the adoption or confirmation. Mr. Editor, point of order. Indeed, regarding the verbatim report, I would like to raise 2 points. First of all, well, in fact, I'm most grateful to the Secretariat for carrying out the task. It is a difficult one. When we tried to suggest amendments, well, perhaps I would like to consult the Secretariat about the approach they have adopted to make selections. Say, for example, for Kenneth Leung, I think he made a mistake. And then the Secretariat was kind enough to correct it. So I want to know whether the Secretariat would carry out such correction in the course of preparation. And then, second point, it is about my part. I think on many occasions, I think they were able to hear my voice, though it was not actually recorded by the microphone. But in fact, when you watched the webcast, you could hear me. But then, under different scenarios, it was treated differently. Sometimes my name was named and it was said what I said. Sometimes it wasn't. Mr. Editor, according to my convention, when we have a verbatim transcript for the minutes, then if a member would like to suggest an amendment or would like to seek clarification, upon receiving your written comments, we'll refer them to professionals in the Translation and Interpretation Division for checking. And then the Secretariat will take up the matter with you individually. So today, before we deal with the comments from members, we're not going to confirm this verbatim transcript. For those members who have pressed the button to speak, are you also on the same point? I think I have dealt with this point of order. Do you have other points of order? Mr. Elvin Young, which point of order? Madam Deputy, I think for the verbatim transcript, I think we need to share with other members in relation to our observation. Probably others have also got their own observations. We've listened very carefully to the recording. So I believe that the relevant discussion should be dealt with so that members may also pinpoint the various observations and carry out an exchange of views. I have a lot of details in my correspondence. I don't think you should just dismiss them. I think this is part of our agenda, and I don't think you can just dismiss it in this way. Mr. Elvin, no, I'm not dismissing it as if nothing has happened. Well, we have already sent out a letter to members inviting you to suggest amendments, and members have already done so. At today's meeting, we're not going to give you the floor to tell us what you want to have amendments, where you have got the amendments, we should leave it in the hands of the professionals in the translation and interpretation division. So the professionals will handle them. They will liaise with you, and they will find out from you about the revisions you are seeking. And then next time we're going to deal with the transcript. In other points of order, I have dealt with this particular point. I need to draw a line. You mustn't repeat the point concerning my ruling. If you're repeating the same point, I won't allow you to speak. Mr. Arnott, indeed, it is not a repetition, but I do find a grave problem. This is because at 1:16 p.m., the House Committee Secretariat sent an email on behalf of the House Committee setting out the various proposed amendments from members, but mine is missing. But I am very certain, and in fact I have printed it out. If the Secretariat would like to make photocopies, it's fine with me. But then at 12:30 p.m., I have already sent out my proposals to the Secretariat. Why is mine missing? For Mr. Horace Zhang, he said that he looked across the waters and he saw Don Quixote on the other side, on the other bank, but this is missing. Well, my name is missing. Well, you said you sent it in 12 something. The Secretariat has tried its best to cover them. Miss Claudia Mo, recently I've been very busy. I don't have enough time to do this, so I haven't written in to protest the verbatim transcript. And I don't actually need a transcript in this way, because on page 45 at the bottom and all the way to page 46, I think that's about my part. Chen Hoi-yen said that it's offensive. I said, are you admitting that it's yourself? I used the phrase trash. I have to stop you from speaking. Mr. Jeremy Tam, please give us your proposal in writing, and it will be referred to the Secretariat. Mr. Jeremy Tam, I have made a decision. For those I've made a decision, please do not dwell on them. Jeremy Tam, what is your point of order? A simple one. Well, regarding the confirmation of minutes, at the last two meetings, I did raise a query. At that time, the matter was put to the vote. You ignored what I said. You didn't want to know whether what I said was true or not. On this occasion, how come that you have made a change and you would like to have a second look? Last time you put it to the vote, and then the pro-establishment camp would not mind whether there were mistakes, and that's your approach last time. How come that this is different? Mr. Jeremy Tam, last time it wasn't a verbatim transcript. It was a summary of your views prepared by the Secretariat. There's no difference for verbatim transcript as the practice of the legislative meeting. Since it is not a sort of a summary for the minutes, so we need to refer the transcript to the professionals. That's our practice. Now, next time, if we have minutes, how are you going to deal with them? Well, I will give you a reply next time if you talk about the minutes next time. Mr. Ted Ho, you have a fresh point of order indeed to pick up the point made by Jeremy Tam, whether it is a verbatim transcript or a set of summary for the minutes. Last time you didn't deal with our proposal. You just have it voted on. Now we would like to have amendments. I think you should also come to the same ruling. You mustn't have double standards. And then last time we had minutes. It's a summary. The Secretariat put it in this way. The Democrats shouted, the Democrats left their seats. That's not neutral. Today, we have a set of verbatim transcript, but then still we have seen inaccuracies, and they mustn't be allowed to happen because you were supposed to listen to the tape. And I doubt if we need to discuss the neutrality of the Secretariat. So how are they able to sort of maintain the neutrality? And what about the SG? He's receiving hundreds of thousands of dollars per month, and he hasn't spoken a word. Well, it's not the Secretariat who are attending today's meeting here that prepared the verbatim transcript. Therefore, we need to refer them to the professionals. That's how we have been dealing with our minutes as well as the verbatim transcript. Mr. Charles Mock, is it a fresh point of order? I think I've dealt with the previous one. If you have got any proposals to amend the transcript, do so in writing. Indeed, Madam Chair, it's a new point of order. Now, the item is called confirmation of verbatim transcript of meeting. So we're supposed to confirm the transcript. Is it because somebody has raised amendments? You're not going to confirm the transcript. When are you going to do so? Would it be left to last time? I don't quite agree with Ted Ho. You don't allow a discussion. So maybe some members haven't yet read the transcript comprehensively, and yet you would like to confirm them. Are you in a rush? Why? And then indeed you have put it down as confirmation. Now you're not going to confirm it. So what about your previous practices? Are you going to change the title of the item and not call it confirmation? At the same time, you disallow discussion. So what is it? Not confirmation nor discussion. Do we simply take out a copy and take a glance, take a look? Well, I've already made a ruling. Unless it is a new point of order, I won't allow further points. Joseph Lee, I'm not sure whether it is a point of order. Certainly, I'm not talking about my observations and whether I want to have amendments. I just want to comment on what Charles Mock has been saying. Now, for the updated agenda, first one is confirmation of verbatim transcript of meeting. We haven't had a discussion. If you have already made a decision that we're not going to confirm the transcript, why would you want to include it in our agenda? Why don't you reword it to say discussion about the confirmation of verbatim transcript of meeting? If we don't have a discussion today, when are we going to have it? Should we confirm it or not? Should we discuss whether it should be confirmed? It seems that you are not allowing us to discuss the 4 pages of observation that I have made in relation to the inaccuracies. So perhaps we should deal with the agenda itself, whether the agenda is in order. Roy Kwong, Rule 6 of the House Rules. I think it is said clearly that the Secretariat should let us check the minutes in due course. Now, Madam Chair, if you are not justified to disallow discussion and airing of opinions concerning the minutes, then it's not right. In fact, the Secretariat has the duty to make sure that we are allowed to have the chance to refer to the minutes. And then for the quorum, if we are to put the matter to the vote, now you should allow us to vote on all sorts of matters. Now this is about confirmation of minutes. Unless you're saying that and fully justified that we need not discuss the matter, we should leave it till not next time. But please be clear as to whether you allow us to have a discussion. We've written in, we would like to have a discussion. Well, as I have said, I'm following the practice. As I have said, if you have written submissions concerning the minutes, in the case of a verbatim transcript, the written proposals of amendments will be referred to the professionals. We'll try to have a discussion and then the House Council would vote on it. I think that's it for this item. Matters arising. Report by the Chairman on her meeting with the CS4A. Well, regarding the Fugitive Offenders and Mutual Legal Assistance in Criminal Matters Amendment Bill 2019, I told the CS4A that at the last House Committee meeting, 13 members expressed their views. The CS4A said that in relation to the views expressed by members at the last two meetings, he would come up with a written reply, which has already been faxed to members for your reference yesterday afternoon. At that meeting, the Deputy Chair, Dennis Kwok, also told the CS4A what he thought. I defer to this Deputy Chairman. I told him that for the government to plan to submit the bill directly to the LegCo, this is going to damage the operation of the LegCo permanently. This is also going to destroy the relationship between the LegCo and the executive. I told him that the CE clearly said in her electoral campaign that she would not need the lobbying of the liaison office, and yet today she relied on the high-profile intervention of the liaison office and asked for members' support. This is a violation of her electoral promise. I've also told the CS4A that indeed we have already formed a bills committee which is ready to carry out the scrutiny of the bill at any time. And in fact, we welcome members joining the bills committee. Well, at the meeting, I also told the CS4A that the least that should be done would be that the administration, the pro-establishment camp members, as well as the pandams, should hold a tripartite dialogue instead of going directly to the LegCo that will be damaging. I also told the CS that we have only set up one bills committee, but some members, as a result of procedural considerations, had different views, and as a result, the bills committee so far hasn't been able to start its work. In addition, the House committee should discuss and decide on the way forward for the bills committee. For members who would like to speak on this topic, please press the request to speak button, and then I have to draw a line. Mr. Jeremy Tam. Madam Chair, yesterday I attended a funeral, namely Mr. Chen Kem Hon, an activist for industrial safety. Well, I need to mention this point. I think we had a leaflet talking about his contribution as well as the appropriate officers that he had taken up. Even if CS4A had written in memory of him, he had been serving the public for over 30 years, and yet for this person who has provided so much contribution to the labor rights movements, he had never been awarded at all. Yesterday at his funeral, we had got business leaders, the CS4A attended, and the Secretary for Labor and Welfare also attended. Now, he was somebody who had attracted so many praises at his funeral. So how come that he had never been awarded with any medals? So you need to consider why the SARG has never recognized the contribution of this individual. Mr. Ang. Well, I've expected the CS4A, Matthew Zhang, and the rest of the SARG would be very pragmatic. Well, at the CE's question time, they shouldn't try to label us. Yesterday or the day before yesterday, at the CE's question time, I told her about my concern about the extradition law, and the CE, that is Carrie Lam, once again accused members of colluding with the foreign forces. And she said that she had to tell the foreign forces not to tell her what to do. Well, today at the Citizen News, we have this report. 31 governments have already written about the concern well before the pandemic carried out the overseas visit.
Your time is up, Mr. Eddie Chu. Thank you. To follow up on what Mr. Jeremy Tam said a moment ago, Mr. Matthew Chung, the CS, have been friends with Mr. Chen Kam-hong for many years. Mr. Matthew Chung should know that Mr. Chan had always wanted to achieve this, and that is hopefully at a symptomatic place, the Hong Kong administration could erect a plaque to commemorate industrial accident victims, and so that when our city becomes more affluent, we should not forget the injuries sustained by workers. I hope the CS has not forgotten about that request. Next time when you meet with him, please ask him whether there will be a timetable to implement this posthumous wish of Mr. Chen Kam-hong. I think this is not a partisan wish. I believe this is the wish of all the parties. Ms. Claudia Mo, I'd like to ask Mr. Dennis Kwok, our Deputy Chairman, when you talk to the CS, I mean, something is still very mind-boggling. The administration is saying that the rendition law must be passed in an urgent manner. But then Taiwan has said time and again that no, even if you pass it, I'm not going to ask for any assistance. So how can they still put forward such an argument? And secondly, Mrs. Carol Lam said that you were actually going to foreign places to collude with the powers there in order to take her to task. But actually, she is putting the cart before the horse, because actually the foreign powers are worried for their citizens in Hong Kong. When people say they have worries, you say that, or she says that that is a kind of interference. So how can she be seen to have any logic in this? I will give the floor to the Deputy Chairman when we come to the end of this discussion. Dr. Fernando Zheng, yesterday I went to the funeral service of Mr. Chen Kam-hong. We saw Mr. Matthew Chung there. All these years, well, actually, it was for 10 years. He was the Secretary for Labor and Welfare. Under his leadership, industrial injury figures never improved. Mr. Chen Kam-hong hoped that we could implement amendments to our laws, and in the interim, our council did not receive any amendment proposals in this regard. I don't know whether it is because we should spend our precious time on other matters. Is it that the administration is not going to do anything before the 12th of June so as to clear the way in order to enact an evil law? Can we have a plaque or commemorative plaque for industrial injury victims? Mr. Ted Hui, I don't know whether you have taken up this with the CS. If not, please do so next time. Tell him and the CE that Hong Kong people don't trust them anymore, because they are ramming the rendition law down the throat of Hong Kong people, which is a regressing of our human rights and the rule of law. And Hong Kong people can be renditioned to the mainland for trial. It is a very shameful, evil law. Tell them that if they want to ram this through, Hong Kong people and Democrats will put up a fierce fight. This has been unprecedented. You know, the CS loves to say this, that this is unprecedented in history. This is what he is doing this time around. Why is he depriving us the chance to scrutinize the law? Why do you want to bypass the BC? Why is it that you think there is such a rush? Is it because that this is a political mission? Again, he has tens of thousands of dollars in salaries every month. He was educated in Hong Kong. He should not sell Hong Kong people down the river. Mr. Kwong Chun-yu, while the rendition law is being pushed through, our Secretary for Justice is involved in another scandal. As you have seen from the media, she is said to still be taking care of 3 adjudication cases without reporting after she has assumed office, and she has not disclosed any details, including the remuneration she received for those 3 cases. When you talk to the CS again, please ask him about it, because the rendition law is going to deal a blow to our judicial system, and it seems people are saying the S4J herself is in the wrong. And of course, when she assumed office, the CE already allowed her to finish off the 6 cases which she was handling. And in fact, those 6 cases should be near the stage of completion. But now suddenly we are told that there were 3 other cases that she was involved in. I hope you will take it up with the CS and let us know more about it. Mr. Ip Kin Yun. Chairman and Deputy Chairman, I hope you will help to refer to the CS our very strong views about the rendition law. As you know, many Hong Kong people are very angry about it, and it has added to the distrust people have in the government. From the letter from Mr. Matthew Cheung to us, he explains that this is to plug a loophole, etc., etc. But now you are taking the bill directly back to Council for resumption of second reading. This is extraordinary. And he explains that it's because the Bills Committee has become dysfunctional. But this is not acceptable to us, because what caused all this? The administration did not do proper consultation. We asked that there should be a tripartite dialogue, and the administration was unwilling. And now, of course, they are starting their propaganda machine. But then if there is propaganda instead of conversation and consultation, the public will not accept it. Dr. Helena Wong, I think you should express to the CS and the administration our dissatisfaction in the following aspects. We actually had wanted the administration to sit down with the pro-establishment camp and us in order to have a tripartite platform to resolve this matter. But the administration said no right at the beginning. So that's the first sin. Secondly, John Lee, he was jumping the gun. Last Friday, we were still having a discussion, and today we are still carrying on with the discussion. Before we have made a decision how to deal with the Bills Committee and how to deal with the rendition law, the administration is jumping the gun. It is already announcing, like the announcement of the King's order, that this will come back to Council on the 12th of June. Isn't that some kind of disrespect for you as chairman and also to us as members? Because we haven't made a decision. So why should we have this meeting at all? This is, of course, administrative or executive hegemony. And, of course, this will destroy the relationship between the executive, the legislature, and the judiciary. Mr. Charles Mock. Next time, Chairman and Deputy Chairman, when you see the CS, please reflect my 2 points of concern. Number 1, this is directly related to Mr. Zhang, and that is he held a meeting asking all directors of bureaus and the permanent secretaries in order to speak to them about the rendition law. I don't know whether, like the previous constitutional reform exercise, they would call everybody in government in order to do publicity, and they actually rented a bus to do publicity in the districts. Now, if this is what they have in mind, I'm sure it will drive a bigger wedge amongst society. I hope you will discourage him from doing this. And I am also aware that many civil service organizations have been contacted by the CE's office, and their political neutrality is affected. And it seems some members of civil service unions have said to newspapers that it has damaged their morale, and some of them are thinking of withdrawal from their unions. I hope they will maintain neutrality. Mr. Leung Yu-chung. Yesterday, I went to the funeral service of Mr. Chen Kam-hong. I could see that the CE, the CS, and other officials sent wreaths. I saw that Mr. Patrick Nip himself at the funeral service. That goes to show that officials of the SARG also thought that Mr. Chen Kam-hong had contributed to the industrial injury victims and helped them a lot. I hope you will tell CS this. Mr. Chen Kam-hong, apart from asking for the erection of a plaque, he is also asking for a commemorative day to commemorate the industrial injury victims. Now, we still have a high number of industrial accidents. So I hope the administration and the business sector should pay more attention to industrial injuries and accidents. I hope you will tell the CS that apart from the plaque, Mr. Chen Kam-hong would also like to have a day to commemorate these people. Mr. Lam Chak-ting, Chairman, please say this to the CS, and please ask the CS to relate this to the CE. Ms. Teresa Zhang, at the Legislative Council a few days ago, she had a very poor attitude answering questions from reporters. First, she pretended she did not understand, and secondly, she interrupted the reporters, and three, she was slighting the reporters in her attitude. I hope when officials come to the Legislative Council, please respect the reporters when they ask questions. Maybe you have no comprehensive answers for them, maybe you have no position to take, but then that is not the attitude she should harbor towards reporters. Lastly, please ask the CS to remind the CE. Her campaign slogan was "We connect, not disconnect." The Secretary for Security only went to organizations and forums held by the pro-establishment camp. As long as the view is different, like the Hong Kong Journalists Association, he did not go to such forums. So it was disconnect instead of we connect. Mr. James To. I will not repeat those points on the procedures of the rendition law, but I hope you will tell the CS about this case. This is about an elderly lady in the Philippines. She came to Hong Kong with her family for pleasure, but she was held up for 3 hours. The message was, first, that she could affect the safety of Hong Kong, so she was not allowed in. And then she eventually was given entry rights, but then she said, no, I would rather go back to the Philippines. Well, this is a major news item internationally. Well, you have to send clear messages to our visitors. Well, you know her background. She was the ombudsman of the Philippines. And she, of course, took the leader of the PRC to task at the international court. But then how can this lady cause any security problems for Hong Kong? Last 2 members to speak, and then I would ask the Deputy Chairman to speak, and then I will conclude this item. Mr. Junius Ho, please reflect to the CS that the police in Hong Kong should be more efficient. On the 12th and 13th of May, I reported to the police about the lack of order in the Legislative Council and the use of forged documents by someone in the council. Well, there should not be any doubts about these cases. If they had decided to arrest anybody, they could have done so. Why have they delayed it for so long? What about our rule of law? And the police always boast of very good performance. I think you should take this up with the CS. If possible, they should arrest somebody before 5 p.m. today. Mr. Dennis Kwok, Chairman, first, we should arrest those who only proclaim themselves to be lawyers instead of really practicing. But first point, this is the 30th anniversary of the June 4th incident. Point of order. Good. Please wait for KK Kwok to finish. Well, let me have my time back. Let him have the point of order first. Mr. Junius Ho, what is your point of order? Well, maybe he was thinking that I was talking about him. Mr. Junius Ho. Chairman. Well, first of all, we should arrest those. You should also arrest people who are killing people because of their neglect. Sorry, Mr. Junius Ho, please. Mr. KK Kwok, please talk about our meeting with the CS. Well, I in fact was not talking about Mr. Ho. Please give me back my time. I really did not want to communicate with him. Well, just tell me what you would like me and the Deputy Chairman to say to the CS. Okay, number 1. June 4th is around the corner. We have found that there have been changes to textbooks when the June 4th incident is not mentioned at all. This is not to be allowed. This is not what our education is about. I hope you will take it up with the CS. And also, the CS and the CE should know about June 4th given their age. They should come out and say something from their conscience in order to ask for vindication of June 4th. And I'm aware that recently our state leaders, especially Mr. Han Zhang, said that he was not talking about the rendition law affecting political issues, but then there are 4 kinds of people who could be prosecuted for political beliefs. I'd like the CS to ask whether that is a lie to Hong Kong people. Mr. Dennis Kwok, Ms. Claudia Mo asked you to answer her. Please do so now. I can be very brief. Well, the CS, of course, has no logic. I believe at our next meeting, I will relate Ms. Claudia Mo's point and her comment to the CS directly. And we will give the member back a very detailed reply. Well, as usual, I have asked the clerk to record all members' views, and then the deputy chairman and myself would take these to our meeting with the CS. Mr. Lim Chek Ting, a point of order. Well, Chairman, I am aware that we have raised many questions. Well, shouldn't there be a mechanism whereby there can be a paper telling us what the CS has said about those points, or else our meetings will become longer and longer? Well, actually, Mr. Lam, the CS has already written in this time around. I'm sure that apart from having a meeting with us, I also hope that the CS can give communication to members who have raised issues with him. I hope he will meet with you so that there will be less tension. Item 3, business arising from previous council meetings. The gazetted subsidiary legislation and also those that will be proposed to council. I will ask the legal advisor to take us through the subsidiary legislation items. Legal advisor, there will be 7 items in 4 groups. First of all, 2 notices. Legal notice 75. This is to add 3 new frequency bands in order to provide 5th generation mobile services. People who use these new additional frequency bands have to pay a utilization fee, which will be decided by auction. The administration has consulted the ITBP on the 10th of May. Members did not object, but then they have raised a lot of concerns. And actually, these 2 notices will be implemented on the 12th of July. Mr. Au Nok Hin, are you asking for a subcommittee to be set up? No, I have a question. Is it that you are also going to discuss the Financial Reporting Council? We are not there yet. We are talking about the first 2 items, which have just been reported upon by the legal advisor. Would any member like to set up a subcommittee? Dr. K.K. Kwok asked for a subcommittee to be set up. Who will join Mr. Charles Mock? The clerk will circulate a paper to members. Legal advisor number 3, legal notice 76. In Hong Kong laws 609C, we are going to include new provisions so that the arbitration center, when exercising its functions, can exempt the $8,000 fee. And then the amendment details are in para 7. The administration did not consult the AJLS panel, and this will come into operation on the 1st of August. Any members who would like to set up a subcommittee? Dennis Kwok would like to set up a subcommittee. Anyone will be joining? The clerk, please circulate a paper. Legal advisor, please continue. The third group includes 3 notices. Legal notice 77 stipulates that the 23rd of September will become the date for the remaining uncommenced provisions of the amendment ordinance. And actually, this was made in July 2015 in order to set up the insurance authority in order to take up the statutory functions of the Office of the Commissioner of Insurance, OCI. This is the last stage of commencement of the amendment ordinance, and this has to do with the new statutory licensing regime and also the taking up of regulation of insurance intermediaries. Legal notice 78, it sets down that anyone can only prescribe the maximum number of authorized insurance at any one time by which he can be appointed as a licensed insurance agency or licensed individual insurance agent. 79. There will be the financial and other requirements of licensed insurance broker companies, including share capital and net assets. On the 15th of May, there has been a paper supplied to the FA panel, and members did not raise any queries. And legal notice 78 and 79 will come into effect on the 23rd of September 2019, same as the amendment ordinance. Okay, about the notices, which are 4th to 6th, any request to set up a subcommittee? Dr. K. Kui Kok requests so. What about other members? Mr. Holden Chow will join. Please circulate a paper.
Fine, I'm sorry. Mr. Edichi, what point of order? I would like to ask the legal advisor. Just now we have two pieces of subsidiary legislation. You have asked members whether they would like to form a subcommittee for that. For 5G, that KK Kwok and Mr. Charles Mok have put up their hands. For at this juncture, so the Bills Committee is counted as established. So the House Committee already made the decision or not. No, you simply make an appeal to members that whoever requests for forms to put up their hand first. So whether the Bills Committee will exist will depends on later. Would that be under RP 74 bracket 4? So making this ruling, but I ask the legal advisor. From my understanding, when members request to form a subcommittee and ask the secretary to circulate, if no objections, and also three or more members joining, that this Bills Committee will be formed and will elect the chairman. Legal advisor, anything to add? Just one more thing. Can legal advisor can expound clearly that the House Committee internally had already made the decision to set up the Bills Committee, or based on RP 75.4, that the committee may allocate it to the Bills Committee for consideration. Mr. Chief, please notice, we just now this is a subcommittee. Legal advisor, just to clarify a simple point, members are aware that to set up a Bills Committee or a subcommittee, there will be a minimum requirement of 3 or more members. So if the House Committee, we have already not less than 3 members joining the subcommittee that it was formed. And like Mr. Chu said, and on the subsidiary legislation we are making the report, that's why we are forming a subcommittee. And final piece of legislation on LSP 80 that stipulated the Article 83 and 85 on the date of operation as for the charges for the Financial Reporting Council, and she will be effective of 1st of January 2022. And the FRC are currently drafting the guidelines on laws, and it will be gazetted before that. And the relevant guidelines not part of the subsidiary legislation. The administration had not consulted the FAP on this ordinance, and the legislature have earlier formed a subcommittee studying this. Mr. Au, what legal advisor to clarify? Just now you mentioned, and in the paragraph 23 of the document, and that the government had not consulted the panel on financial affairs. So is it actually within procedures? And if possible, in the future, is there any chance to review the relevant statutes? Legal advisor? And for whether subsidiary legislation, we need to consult the relevant panels. The administration would do so on a merit basis, but not a mandatory that all subsidiary legislation must consult the relevant panels before being gazetted. And just now, what we're mentioning is really a commencement notice. And the relevant provisions has already been studied by the Bills Committee. And Mr. Au can set up a bills subcommittee and where he can make inquiries to the administration. Are you asking a bill subcommittee to be set up? Anyone second? Mr. Charles Mock. Any other members joining? Mr. Al Lochin. Can Secretary circulate? My members, as for the notice to make amendments to this that would on the 19th of June council meeting. And if you decide to post on the deadline, it can be delayed to the 10th of July meeting. And fourth item on the agenda, further business for the council meeting of 29th of May 2019. 8 questions. Mr. Wilson all have replaced his oral question. And B, a members' motion on subsidiary legislation and instrument. The deadline for extended period for amending subsidiary legislation and proposed legislation to be moved by Honorable Wang Qinghua in relation to 5 items of subsidiary legislation relating to the Central Military Dock. The purpose is to put the period for amending legislation have delayed to the 26th of June council meeting. KK Kwok, what point of order? The first question. Our question for our next question meeting is by Mr. Xiu Ka-chun, and he is in prison for political prosecution. Since he's the most important person in the oral question, whether the Secretariat and the President notified that Mr. Shaw intend to return to LegCo to ask the question himself, and the LegCo president, or for yourself, or the secretariat, and what have you all done, and what is the eventual arrangements? Well, understand that Mr. Shaw continued to ask his oral question by a designated member, or I can ask on his behalf as the chairman of the House Committee, and I have communicated with the president, and the president will deal with his request as per RP. What point of order, Mr. Chow? Just now, Dr. K.K. Kwok leveled the accusation of political prosecution as a serious accusation. I wish to clarify. You asked Mr. K.K. Kwok to clarify. You can choose to clarify or not. Of course, I do clarify. The 79 days Occupy Central movement is stemmed from the August 31st NBCSE movement that deprived Hong Kong of universal suffrage. And Hong Kong people who stand out was furious. And Mr. Xu and the other Occupy Central activists, this prosecution, we all know that the Department of Justice are making a political prosecution. That is true, and he finally gone to the prison. How about this? Let me just consult other members for the 79 days of Occupy Central movement. Okay, your time is up. Mr. I wish to raise a point of order. Yes, I just replied to Mr. Yeah. What? In public nuisance is an obsolete crime. Mr. Chow asking Dr. Kwok to look about. I'm requesting Mr. Chow to clarify. To clarify that this is a political prosecution. The public nuisance have been said to outdated in Australia, and you use it to prosecute a Hong Kong democracy activist. Mr. Au asking Mr. Chow to clarify, were you willing to do so? I hope that since we are reporting the business for the council meeting, I hope that that you keep your questions concise. Mr. Chow willing to clarify. Chairperson, I'm not going to start a debate here, but I must make it clear. Just now, Dr. K.K. Kwok, this political prosecution is definitely a mistake. What point of order you wish to raise? I think the LegCo should speak out for our colleagues, and Mr. Xiu Ka-chun is now in Stanley prison. But from I understand, he would like to come to LegCo to ask his oral question. But unfortunately, the Corrections Service Department denied his request. And LegCo a different organization to try to help the member to fulfill discharge his functions. Mr. Allen remind you that what you said is not will be discussed at this item. I would only allow you to raise genuine point of order. If you'd like to debate whether to let Mr. Xu to kind of let you go to ask this question, I'm afraid I will not let you speak here. Mr. Eddie Xu, with point of order. Well, you can decide whether it is point of order or not. So Mr. Xu had applied to the CSD, and the CSD replied that you are not entirely indispensable. However, he is really the questioner for the first oral question. If he didn't make a written authorization to other members or the House Committee Chairman to help him ask this oral question, does that mean it will become unnecessary for him to ask the question himself? If he didn't authorize anyone else, then he would lose his oral question slot. So that means that the agenda is incomplete. Can you clarify with the CSD the status? Maybe the CSD has understood our procedures. Mr. Chu let us said the item is simply report the further business for the next council meeting. As for the handling of the Mr. Xu's oral question, we need to follow different regulations and RP. I'm sure the President and the Secretary will follow the RP instead of what we discussed here. If we start a debate, I must stop you. Secretary, anything to add how you will handle this? As Secretary General, Mr. Xu had already written to the Legislature President requesting the President's permission to allow Ms. Dr. Fernand Chang to ask questions on his behalf, and the President has approved that and replied to Mr. Xu. So let's see the latest development. We ask the members who press the button to any new point of order, then we shall move on to other items. Please do not enter the Xu Kachin's matter. Please join lines. We shouldn't be ended to debate. I remind you repeatedly. Dr. Chang, what clarification? What point of order? The Secretary General mentioned my name, and now we're discussing questions for the council meeting on 29th of May. And Mr. Xu do have allocated oral question slot, and Secretary General said this. Mr. Xu had made such requests, and the Legislature President had approved it. But from what I understand, Mr. Xu didn't mean that way. Maybe what I got is the latest. The Secretary General's news was dated. Mr. Xu hoped that he can ask his question in person at Let's Go, and I suggested the House Committee to write to CSD and asking the CSD to approve Mr. Xu's that on the May 29th meeting to come to the council meeting to ask his oral question. Dr. Cheng's, your request outside of the scope of this item. Please do not enter debate in this item, and your comments and latest information, the Secretary and the Legislature President will take note. Any other new point of order? Mr. Charles Mock, you don't let people speak because we have to rectify incorrect information. Me and Deputy President and Professor Joseph Lee had visited Mr. Xu this morning. He explained to us that his latest position, while he's still thinking how he should handle it, but he most wanted to ask the question himself, so I can follow up the question himself. And also, it's a duty to his social welfare constituency. Well, I agree with Dr. Cheng and hope that you or even the President can explain the reasons to CSD why the member should attend the question President himself, and what's the difference by appointing a representative. You can't allow real discussion just on the letter described by Secretary General that Mr. Xu told us very clearly that he very much would like to ask his question himself in legislature instead of delegating to others. I think your views are clear enough, Mr. Ted Hui. Well, Secretary General, well, do you have a point of order? Well, if this is discussing, we can't discuss this. Well, we're dealing with the questions. Why can't we discuss that? Because, well, the president would the one deciding on the agenda. As a Secretary General, please stop quoting false information. If you like to know what Mr. Xu will think, you can go visit him himself and get his instruction instead of misleading members here. Well, whether he can come to ask a question or not would definitely affect whether he get the mandate to ask questions. What we have. And now he definitely can come, but just not allowed by other departments. I think the House Committee and the President should write to CSD to show us that we support Mr. Xu to come to LegCo. That is the public mandate to him to speak as his members' duty. I remind you that this is just notified members that we have a question session. As for the handling, we let the Secretariat and President to follow the RP rules. And Dora, Secretary, which just now the Secretary General was the latest news from what we know, because we received Mr. Xu's letter. However, today we haven't received any written correspondence. So at the Secretary position, news is the latest situation we got hold of. He mentioned in his letter that he applied to come to release from prison to ask a question, but CSD denied the request. That's why he said he want his question to be asked by Dr. Cheung on his behalf. That's the latest piece of information received by the Secretariat. And the members also relayed this morning meeting. The meeting. I'm sure that Mr. Xu is our member. Of course, at the House Committee, if he as electoral council wished to attend his own oral question, I'll say that at this point that we can speak. We very much hope that with the President's chairman we can have a deep discussion in HC so that since the LegCo PMP Ordinance would authorize a member if offer protection on his way to the meeting, even if he's in prison. He just hoped that to ask his oral question. I noticed that in previous HC we had discussed that before. Maybe this is preceded, but as for anyone who had tried it or applied before. But for why this time the CSD had refused Mr. Xu's request twice, maybe it is the right occasion to speak out for our colleagues for his right to ask question. Well, I met Mr. Xu this morning, and for Mr. Xu, I can provide you information to Secretariat. That's the end of the discussion. Item number 5. Business for the council meeting of 5th of June. A, questions. The LegCo meeting had raised 22 questions, 6 oral questions, and 16 written questions. B, bills and bills first and second moving on second reading. We haven't received any notice, and for government bills, we haven't received any notice yet. D, members' motions. On that day, we will deal with members' motion carried over from previous LegCo meetings. And for the report on other subsidiary legislation and other instruments by the House there were two. We already tabled the list of subsidiary legislation which expire on the middle of June. If you'd like to speak on the subsidiary legislation, and please notify the Secretariat on May 28th before 5 o'clock.
Reports of Bills Committees and Subcommittees. A, report of the Subcommittee on Insurance Prescribed Fees Amendment Regulation 2019. Mr. Wang Dingguang, Chair of the Subcommittee, please speak. Thank you, Madam Chairman. The purpose of the Insurance Prescribed Fees Amendment Regulation 2019 is to empower the Insurance Authority to collect user fees for 12 items of service so as to recover the cost. The SC held one meeting with the administration. Members were mainly concerned about how the IA determined the levels of fees and whether the IA had consulted the insurance industry. The IA has explained that it adopts a cost recovery principle in determining the fee levels of providing specific services. that is, according to the efforts and time required by IA to provide the requested service. IA has subsequently provided the details for working out the new fee items. IA has advised that they had consulted the insurance industry on the fee proposals. The industry generally found the proposed items and fee levels acceptable. This subcommittee raised no objection to the amendment regulation. Please note our deliberation detailed in the report. Thank you. Thank you, Mr. Wong. B. Report of the Subcommittee on Subsidiary Legislation to implement the latest requirements under the Conventions of the International Maritime Organization. Mr. Frankie Yik, Chair of the Subcommittee, please speak and report. Thank you, Madam Chair. The subcommittee has completed scrutinizing the 5 items of subsidiary legislation to implement the latest requirements under the Conventions of the International Maritime Organization, IMO. The IMO prescribes marine safety standards via various international conventions. As an associate member, Hong Kong has an obligation to update local legislation to give effect to the latest requirements. Since 2014, the IMO had adopted several new requirements under the International Convention for the Safety of Life at Sea and the International Convention for the Prevention of Pollution from Ships in relation to ships operating in the Arctic and Antarctic waters in relation to the discharge of sewage within the Baltic Sea Special Area. The subsidiary legislation deliberated was made to give effect to the latest requirements in Hong Kong. The subcommittee held one meeting with the admin on the 29th of April 2019. Members deliberated on the progress of the incorporation of international maritime conventions, the compliance of Hong Kong ships with the latest IMO requirements, registration of ships in Hong Kong, and the training of seafarers. The details are set out in the SC's report. The subcommittee supports the 5 items of subsidiary legislation and did not propose any amendments. The period for amending the subsidiary legislation has expired and the legal notices will come into operation on the 31st of May 2019. Thank you, Mr. Yik. C. Report of the Subcommittee on Toys and Children's Products Safety Ordinance, Amendment of Schedules 1 and 2, Notice 2019. Mr. Ng Wing Kang, please speak. Thank you, Madam Chair. The subcommittee has completed scrutiny of the Toys and Children's Products Safety Ordinance, Amendment of Schedules 1 and 2, Notice 2019. The notice was made by the Secretary for Commerce and Economic Development under Section 37 of Cap 424 to update certain safety standards for toys and 5 classes of Schedule 2 products, namely child safety barriers for domestic use, children's cots for domestic use, children's high chairs and multi-purpose high chairs for domestic use, children's paints and playpens for domestic use. Under Section 3 and Section 5 of Cap 424, no person shall manufacture, import or supply toys and children's products unless they comply with all the applicable requirements contained in any one of the safety standards specified in Schedules 1 and 2 to Cap 424. The subcommittee held one meeting with the administration. Members have expressed concern and inquired about the scope of Cap 424, the safety of individual children's products, and enforcement work, as well as the dissemination of safety information of the relevant products. The details are set out in the SC's report. The notice will come into operation on the 1st of October 2019. The subcommittee supports the amendments contained therein. Thank you, Mr. Ng. The report of the Subcommittee on Registration of Persons, Application for New Identity Cards Order 2018, Amendment Order 2019. I would like to invite Mr. Gary Chen to speak. He's the chair of the subcommittee. Mr. Chen. Thank you, Madam Chairman. The subcommittee completed the scrutiny of the Registration of Persons, Application for New Identity Cards Order 2018, Amendment Order 2019, under which holders of target Hong Kong identity cards born in 1955 to 1959 or those in 1964 to 1967 are directed to apply for new Hong Kong identity cards at a replacement center within the specified period of the second cycle of the replacement exercise. The subcommittee has held one meeting with the administration. Members noted that there are certain facilitation measures in the replacement exercise for the elderly, namely applicants for Hong Kong identity cards within the period specified for the age groups may bring along up to 2 persons aged 65 or above to replace their Hong Kong ID cards together during the same visit to a replacement center. Some members consider that it is desirable if the facilitation measure for elderly persons can be extended to also cover persons with disabilities. There's also a suggestion that District Council members should be accorded a higher priority in the replacement exercise so that they will be familiar with the procedure at the earliest possible time and be able to help the public. It is the administration's plan to introduce further legislative amendments to the 2018 order later in 2019 for implementation of the third cycle of the replacement, while introducing a new arrangement for District Council members, as well as new facilitation measures for persons with disabilities in the same exercise. This work of the subcommittee has been set out in our report. Please note our report. Thank you. Item 7, position on bills committees and subcommittees. We have 13 bills committees in action, 10 subcommittees under the House Committee, and also 2 considering other business, 7 studying policy issues under the panels. Well, Mr. Chu, this is the 3rd consecutive week that I'm asking this question. That is, I would like to take up the work of the Bills Committee. You have a table on page 3. Bills Committee on Fugitive Offenders and Mutual Legal Assistance in Criminal Matters Legislation Amendment Bill 2019. The meeting held on the 6th of May is missing. On both occasions, the Secretariat and the LA told us that it has been addressed and it is a sub judice case. Now, I think it has become an academic exercise, but in any event, the LA, the government, and the SG should tell us why the meeting held on the 6th of May is not being given recognition. You can't dodge the issue, because today, if we are to endorse Mr. Holden Chow's incorrect motions, then it would not be right. Mr. Chu, well, as in the past, for your comments and for your suggestions, they will all be recorded by the Secretariat. Now, for this particular item, we are not here to talk about the operation of that particular Bills Committee, so I won't allow a discussion. Well, here I would like to check with the LA to see if he has got anything to add. Thank you. Both the SG as well as the LA has spoken at the last 2 meetings on this matter. We haven't got other things to add. Jeremy Tam, point of order? Not a point of order. I want to have a discussion on this matter. Yes, please. But we are not here to have a discussion. But then I want to talk about the position on bills committees and subcommittees. So I want to speak to this item. Yes, please reset the timer. Well, I would like to talk about subcommittees in action. I know that we are still having a number of them waiting in the queue. Like under the housing panel, we have got a subcommittee concerning inadequate housing, as well as another subcommittee in relation to the beauty industry. Both of them had 5 meetings. I want to know whether we usually have 6 meetings in a year for a typical subcommittee. If that is the case, please tell us roughly when we're going to see the completion of the work of those 2 subcommittees. Clerk. Well, unless otherwise directed by the House Committee or unless otherwise agreed to by the House Committee, for subcommittees under panels, usually we have a 1-year time limit. So a subcommittee is expected to finish the work in a year's time, and then upon completion, a report will be made to the House Committee. I think we have talked about that in the past. Mr. Jeremy Tam, well, in order to facilitate our understanding of the upcoming expiry of deadline for the work of a subcommittee, well, say for example, for the subcommittee on inadequate housing, it was formed on the 15th of November. Can I take it that it would last until 15th of November this year. I think it has been renewed once only. Can it be renewed once more? It is difficult for me to tell when it will come to an end. So would you like to add a column? Would it be better to have a column here? That is, give us the latest position. That is when it is expected to finish its work. But of course, if there is a need for the subcommittee to continue, that's for separate discussion. Otherwise, as it stands, it is difficult to understand. Yes, maybe the clerk can take up this point. Well, let's take, for example, the Joint Subcommittee on the West Kowloon Cultural District Project. Well, I think we have already got a column called remarks. There is a particular House Committee meeting. Permission has been given to continue the work. We have also got the date of the first meeting in the third column. So you just you can tell how long it will last. That is in a year's time. If you have got any good suggestions, you can do so after the meeting. You just want to make it better, right? Well, it was set up on the 15th of November 2016. I think the chair as well as the deputy chair were elected. So probably the duration has been extended. But this point is not mentioned in the column of remarks. So it is very odd. It doesn't talk about the date that the House Committee set up the subcommittee. You simply give information about the chair as well as the deputy chair. Is it odd? I think you just want to make the table easier to understand. Maybe the clerk doesn't fully understand what you are driving at. Please take up the matter with the clerk after the meeting. I appreciate your efforts to make the table easier to understand. All right. Item 8, Item 8, senior judicial appointments. Well, in fact, on the 22nd of May, the CE made an announcement. Namely, first of all, the Right Honourable Lord Jonathan Sumption as a non-permanent judge from another common law jurisdiction of the Court of Final Appeal. And second, the Honourable Mr. Justice Jeremy Poon Siu Cho as the Chief Judge of the High Court. Well, according to the appointment procedures that we have endorsed, it will be up to the House Com to see whether they would like to set up a subcommittee to consider the relevant recommendations concerning the appointments. Priscilla Leung and Dennis Kwok would like to set up a subcommittee. Well, the administration is going to, well, in this case, I would invite membership from you. Horace Chung, Holden Chow, Jonas Ho, Secretariat, please circulate paper, Fernando Zhang, etc. Well, the administration will wait for the subcommittee's report to the House Com before asking the LegCo to agree to the recommended appointments. Item 9, way forward for the scrutiny of the Fugitive Offenders and Mutual Legal Assistance in Criminal Matters Legislation Amendment Bill 2019. The way forward. Well, in relation to this matter, it was given the second reading on the 3rd of April, and then we set up a subcommittee. We had 5 weeks and 4 meetings, and so far we are not able and we haven't started the actual scrutiny, while at the same time we have something unprecedented, confrontation, physical clashes and injuries, etc. Well, all of us across the political spectrum in relation to such internal strife and injuries, we feel sad, and it is said that we should be seeking for a rational way forward so as to prevent having something like this happening. Well, at our last House Committee meeting, when we talked about the way forward, I had already given members the chance to speak, hoping that we can arrive at a consensus. However, after almost 2 hours of discussion, in relation to the way forward for that Bills Committee, we were still very divided. We were not able to reach a consensus. Well, in fact, the society would like to see the work of the Bills Committee moving forward. And in fact, we have this constitutional duty. We cannot shirk the duty. Before the close of last time's business, I asked you to give written submissions concerning the way forward, so that at today's meeting, we are able to have a focused discussion. And then in due course, we can come up with a decision called upon by our constitutional duty. And then on the 20th of May, as the chair of the House Committee, I received a letter from the Secretary for Security, and he clearly said that in accordance with Rule 54(5), he would like to resume the second reading debate of the bill at the 12th June LegCo meeting. I need to give a reply to the Secretary after today's meeting. I will first of all listen to your views before I decide what to say to the Secretary. As of 5 o'clock on Tuesday afternoon, I received altogether 9 submissions or 9 options from members, and the relevant proposals have been sent to members together with our agenda on Wednesday. And later on, the House Committee, in relation to the proposal from the S4S to resume the second reading debate on the 12th of June, as well as these 9 proposals from members, we're going to have a joint discussion. I will invite members to speak in accordance with the order that we received the options, and then I will open the floor to other members. After that, we will deal with motions moved without giving notice. In accordance with our usual practice, I will first of all invite you to decide whether you agree to deal with the motions. And then, if you agree to deal with them, I will invite members to decide how to deal with individual motions. I want to say that so far we have received 3 motions from members without giving notice in advance. If you want to do the same, please do so before 4 o'clock in writing. Please submit your proposals to the Secretariat before that time. After dealing with the motions without notice, then if you have different views concerning the resumption of the second reading debate of the bill at the LegCo meeting on the 12th of June, I will put the matter to the vote. That will form my basis of my report to the administration. And then I will invite members to vote on the different options. Eunice Ho, Tony Chair, Regina Yip, and Eunice Young have told me that there's no need to put their options to the vote. Therefore, later on, we're going to vote on 6 options. Some of them may be mutually exclusive, so if some of them have been endorsed, then some other proposals, in accordance with our voting procedures, cannot be put to the vote. As to the details, you can refer to the table concerning the voting arrangements. It has already been sent to you and tabled for your reference. In addition, at our last House Committee meeting, members had already agreed that the part of the House Committee meeting in relation to the discussion of this bill will be having a verbatim transcript. So for today's meeting, we are going to have a verbatim transcript. Mr. Roy Kwong, point of order. Well, what about the order? So you'll give the floor to those who have put in written submissions, or can I start first? I already said that there will be a joint discussion. So regarding the S4S plan to resume the second reading debate on 12th of June, we can have it discussed together with those submissions from members. Well, after listening to your briefing, well, among the different options proposed, it seems that by endorsing Holden Child's motion, then all the others will be killed, because if one has been endorsed, then the others would not need to be put to the vote. Would it be fair if you allow him to refer the bill to the LegCo meeting directly? It is very wrong. Well, regarding the voting arrangements, well, I have made the decision in accordance with the timing that your submission reached us. I think this is the same approach we've adopted when we conduct our other panel meetings. Well, you talked about being regrettable, etc. I think you were reading from a script. If you do have a script, please show it to us. I cannot agree with you in relation to the many adjectives, qualifiers that you have chosen. I think you are to be blamed to a large part because you failed to discharge your duty as the House Committee Chairman. Shut up, please. So I want to have a copy of your script, and then I want to ask a point of order regarding the S4S, that is John Lee's letter. He wrote to the president of the LegCo asking for the resumption on the 12th of June, and then he tried to put up a show. He wrote to you afterwards. So he's not respecting you. Now you represent the House Committee. On behalf of us, you should tell him that maybe we don't accept 12th of June. He should choose another date. I think probably the result will be the same. He would not want to accede to your viewpoint. So please tell us the following. I'm not sure about the outcome of today's discussion. Maybe the pro-establishment camp members would listen to the voice of their conscience and they don't want to betray Hong Kong's people. So if 12th of June is being vetoed, and if you refer this answer to John Lee, is he still trying to ram it through the LegCo on the 12th of June?
Okay, I will listen out to the points of order before I respond. Mr. Charles Smock, a point of order. You just said something, and I need to clarify that with you. You read out from a script, but then I found that it was full of views that are far from neutral. No matter what your own views are, you are the chairman of this committee, and we all expect you to adopt a neutral stance. But then in one paragraph, you said that society commonly want us to take forward the rendition law, but actually we have heard the majority saying that this should be withdrawn. Well, of course, you can say if we take it forward, it would mean that it includes withdrawal, but then withdrawal means that it doesn't have to be taken forward. So I don't think you should insert your own opinions in your opening remarks. We have had 4 meetings, but then you don't recognize them. I think legally speaking, that is going to be a big problem. Even if you want to vote on different points on this agenda item, you can't really put in your own opinions into your opening remarks as if the entire House Committee agreed with you. Dr. Helena Wong, Chairman, you said that John Lee announced on the 20th of May that he would like to resume second reading debate of the fugitive law on the 12th of June. And today we are on the 24th, and you are compelling us to make a decision within just 4 days because you have to reply to John Lee. The executive would like to rush it through, but then it cannot ignore our usual rules and procedures. Why don't you ask John Lee or the CS or even CE to come to our House Committee to explain to us why there is the urgency? Shouldn't they talk directly to members here instead of having us fight it out at the House Committee here? Where is the executive? Isn't the executive accountable to the legislature? Why should it be issuing orders to us? How can we monitor the executive? Why don't you ask them to come here and answer our questions? Where is John Lee? Claudia Mo. First, I will ask Starry Lee to say loud and clear whether you were reading from a script, right? We knew that it was a script because people could have photographed you. So was this a speech prepared for you by the clerk, or was it from your heart? Where is your neutrality? The legal advisor has to explain in detail. You said that we should take this fugitive law forward. Nonsense. We are asking you to stop it. We have told the administration to withdraw it because of the huge controversy attending this bill. But also we look at the order for voting. First, the S4S proposal, and then another one who is called Holden Chow, saying that we should disband with the decision to set up a Bills Committee, and then these two could be carried, and then you said all other things would not be voted upon, and the Democratic camp should just shut up. What kind of a meeting is this? No, not here. I heard some DAB members shouting for people to shut up. Well, as legislators, we are not like DAB members who have private communication with C.Y. Leung, so C.Y. Leung could amend legislative papers. Is it that in your concept, the executive and the legislature are just part of one another? I wouldn't be like you, that we would allow direct taking of the bill back to legislative. We must be analytical and judgmental in making decisions. Whether or not there is controversy within council, we should follow the procedures. Now John Lee is telling you to do something and you just say, yes, yes, yes. Okay, we'll listen to you. What is important is that we should go for Article 75(18) of the Rules of Procedure, because it says that this should not be dictated by the House Committee. This will be decided by the committee and its subcommittees. Mr. Eddie Chu, I have a rather complicated point of order. I hope you will allow me some time, because I have already read the Holden Chow's proposal, and I think he is not abiding by the rules. Please allow me to read out from a script, because I want to make 2 points. Number one, Mr. Holden Chow is basically saying that the House Committee should rescind its decision to set up a Bills Committee. According to what the legal advisor said just now, on the 12th of April, 3 or more members asked to set up a Bills Committee on the fugitive law. So the Bills Committee has been set up. But does it mean, as Holden Chow was saying, that the House Committee decided to set up that Bills Committee? I don't think the two are equal. The Bills Committee would act according to ROP 76.1 and 76.1a and 76.3, and with the consent of 3 members, the BC was set up, and then according to 75.4, this would be referred by House to the Bills Committee to study the bill. And on the 12th of April, the clerk sent us a paper not saying that the House decided to set up a BC. It said members agreed to set up a BC to scrutinize the bill. So the premise for Mr. Holden Chow's option does not stand, because there was no decision of the HC to set up a BC. The second part is simpler. Holden Chow is basically asking us that the House Committee should rescind a decision made by ourselves. I refer to the ROP and the House rules, and the HC was not authorized to do that at all. Okay, even if we say that we could apply ROP 32, that with regard to previously made decisions, well, let us look at 32 bracket 2. I think we are in a similar position, and that we are in a position similar to negative vetting. Actually, when the House Committee agreed to make a decision to set up a BC, it was a case similar to negative vetting. According to 32.2, there cannot be another motion on the same issue. So I'm of the view that Mr. Holden Chow's proposal is not in line with rules of procedure, so it should not be voted upon. Dr. Fernando Zheng, of course, I agree with the analysis of Mr. Eddie Chu, but I'd like to raise another point of order. Under this item, the voting order is first to vote on the S4S letter. The letter states very clearly that he is acting according to ROP 54.5, that he would consult you as the chairman of the HC. According to me, 54 or 55.4 would say actually that we should be the ones saying that we are ready for second reading. So it should be up to us here at the House Committee to discuss the matter. Since we have put forward so many options and proposals, you should at least first vote on our own proposals. Why is it that we have not even attended to our own proposals, and then suddenly we should go first to the proposal by the administration? This is against what the ROP says, that we should decide that we are ready for second reading. Therefore, S4S letter should come last in the voting order. Dr. Cheng Chung-tai. Thank you, Chairman. All along, I have said that the BC is already doing its scrutiny work. It is chaired by Mr. James To. That meeting has held, or that BC has held several meetings. But what is regrettable is that the administration and also the Legislative Council Secretariat, they are not cooperating with the Bills Committee. And the S4S is now saying that the LegCo is not exercising its duty under the Basic Law to scrutinize bills. But that is, of course, not a factual description. Therefore, this time around, when we think about the way forward for the BC, I'm of the view that the Security Bureau and the administration have not taken up their responsibility to help us scrutinize the bill, so I'm asking them to retract the bill. Mr. Gary Fan, this is a point of order. Please listen to me carefully. And I'm talking about the voting order that has been tabled. I think that this is a wrong approach. You are saying that on the 20th of May, the S4S wrote you wanting to take the bill back to Council on the 12th of June. But then at the same time, we must remember that on the 17th and the 29th of April, Mr. James To conducted two legitimate meetings of the BC, and at the end of the second meeting, we were almost going to elect the chairman. But then on the 4th of May, you chaired a special HC, and then you actually passed a guideline. And with the assistance of our SG, who is not neutral, in fact, I think he has abused his power. And therefore, on 6th of May, James To continued to be presiding over the meeting, and he became the chairman. And what is before us is to allow that meeting to continue and that BC to continue. If you are going to vote on the S4S proposal, and then whatever is proposed by our 6 members, as long as they go against the S4S proposal, then they will not be voted upon. Now, you said just now that you would arrange meetings to listen to our proposals and discuss our proposals. I think your arrangement is unreasonable, Mr. Jeremy Tam. I'd like to go back to Mr. Eddie Chu's points. Just look at Mr. Holden Chow's proposal. He is asking for the HC to rescind a decision made by itself. The LA, when he answered another question, he said the decision to set up a BC would be such that the HC would ask whether anyone would be joining a committee, and if 3 members raise their hands to join, then at that moment, the decision of the HC has been made to set up a bills committee. Therefore, it is not right for Mr. Holden Chow to say we would rescind a decision. If he wants to disband the BC, well, that can go. But if he is talking about rescinding a decision of the HC, well, actually the HC did not make that decision. It was only consulting members' views. And the moment for the BC to be set up was the moment when 3 or more members raised their hands. And the committee was set up by the members. It was not set up by the decision of the House Committee. Okay, we will deal with the first round after a few more members have spoken, and I will draw a line there. Dennis Kwok. Thank you, Chair. I have a point of order. I'd like to ask Mr. Holden Chow a question. Since you always collude in private with our investigation target, namely C.Y. Leung, I must ask about the writing of this letter. Before you wrote this letter, Mr. Holden Chow, did you privately liaise with Mr. John Lee or government officials? And the purpose of your writing this letter, was it to assist the administration, or was that this letter was totally written by yourself? I have to clarify that first, because if you would tell me that you asked officials beforehand, I would like to know which member you asked. Mr. Dennis Kwok, this is not a point of order. If you want to have an answer from Mr. Holden Chow. No, I'm talking about previously asking or communicating with officials before you wrote this letter. Okay, Mr. Holden Chow, you would have the chance to speak later on because you will be able to introduce your proposal. Mr. Alvin Young, I am going to need the assistance of the legal advisor for the House Committee to rescind its own decision to set up a Bills Committee. Where is the power? Where is it in the rules of procedure? Have we seen anything like that before? Do we have that experience? Number two, if we can rescind a decision of the House, does it mean that next week we can rescind the decision of Mr. Holden Chow next week, and then the week after next, another member can rescind the decision of the next week? Can this just go on and on like that? Is it feasible? I'd like to know where we have this authority or power in the rules, and where do we draw the line? If we can't have a clear answer, then you are turning this House into a private club, meaning the majority can decide about the operation of any committees, but then this is illogical and this is not well-based. Mr. Gary Chan. Chair, I don't think we should attack members on the basis of rules of procedure. I, for example, won't question members of the Democratic camp for writing their letters after going overseas. What I like to talk about is the order of voting. Some members question that, but I agree with you. Why should we go for the proposal of the administration first? It is because when there is a proposal from the administration to go directly to the council, it changes the entire environment of this Bills Committee. Without that letter from the administration, of course, we should discuss according to the order our proposals are submitted. But now the administration has made this proposal, we must consider that situation and whether it would throw any light on our own proposals. Therefore, we should first deal with the letter from the Secretary for Security. I'd like to hold here to deal with the points of order mentioned by 10 members. First of all, as chairman of the House, well, like other members, we must defend the power of the Legislative Council to scrutinize bills as provided for in the Basic Law. It is also our duty. Before I allow this to be on the agenda, I have considered 73(1) of the Basic Law that we should act according to the law to scrutinize bills and also to make legislation. And actually, such procedures are not mandated to have to go through a Bills Committee. And the Secretary has also said that he is acting according to 54(5) of ROP in order to follow the ROP, and it is not hurting or derogating from the powers of the Legislative Council and its duty to scrutinize bills and make laws. Therefore, I am of the view that I have the duty to include that letter in this agenda item, and I cannot see why I don't put this matter on the agenda today for your discussion. Actually, as the chair of the House, I have received this letter from the Secretary, and I must discharge my duty because he was consulting me as chair of the House. And when I give a reply, I must base my reply on your views. Therefore, I have decided to include today's discussion in our agenda today. Secondly, I'd like to ask the legal advisor to respond to points with regard to the Bills Committee. Well, later on, you can press the button. The script was written by me. It reflects my feelings. You may choose to differ, and I can well understand. As I said many times, as the chair of the House, I will have regard for your views as the basis for my reply to the Secretary for Security, and you still have the chance to speak if you have a different view. Legal Advisor. Thank you, Chair. On the setting up of Bills committees, well, it is a procedural point, and if necessary, the SG or the ASG can assist and come in later. As far as I understand, the bill was read for a first time and second time on the 3rd of April. And according to 54.4 of the ROP, it was adjourned and the debate would be taken up by the House, and this is referred to the House on the 12th of April at the meeting of the House. According to ROP 75.4, the House decided to refer it to a Bills Committee. According to our record, at that meeting, over 3 members expressed that they would join the Bills Committee. So at that time, there was already a quorum for the Bills Committee to be set up, and I can also give more information for the reference of members. Actually, in the House Rules 20G, it talks about the setting up of Bills Committee, and I will quote that the House Committee will consider the information provided by the administration, advised by the legal advisor, the number of Bills committees, and the urgency of the bill to decide whether to set up a Bills Committee. So from these relevant provisions, we understand that this is the procedure for setting up a Bills Committee. Thank you.
Anything to add as for whether you can rescind the powers or repeal the powers of the Bills Committee, and just if necessary, the ASG and the SG can further supplement. And Mr. Chu mentioned that RP 32, and for the earlier decisions, and how do we deal with motions on the previous decision of Council? When a Council has taken a decision on a specific question, and the question has been decided in the affirmative, no further motion shall be moved in relation to the question during the current session, except a motion to rescind the decision moved with the permission of the President. The President, it can so be interpreted that on the 12th of April that we made decision that we would set up a Bills Committee to scrutinize the bill. If today we changed the decision made by the that HC meeting, it will see that the HC committee is moving a motion to rescind the decision. That's the established practice of the Council. As for the House rules arrangements, you would apply the same logic. Legal advisor, can you confirm that? Chairman, when the chairman decide to table what kind of documents and items on today's agenda, you would take into account that RP 32 and the chairman of the House Committee had included Mr. Hodenshouse a motion on today's agenda to members debate and decide whether to rescind on the House HC decision to set up the Bills Committee. Second round opponent orders. The legal advisor went the garden route to Ordinance and failed to point out which specific provision to where the basis to rescind the previous HC decision. Over 32 RP is not what is it about. You try to apply logic, you can't explain in black and white that whether you can rescind that decision. So when the legal advisor decides to evade the member's question. So this agenda item cannot withstand legal challenges that do not allow the House rule by the House rule and the RP. And we shouldn't be discussing this today, since for the Bills Committee at the fugitive bill has already been decided and already started scrutiny. I don't see why do we have to rescind this. I don't see what role the government have to write to Legislature that you can't handle it. Therefore, we send it directly to the council, and then we'll work with him to repeal our previous procedures. You are depriving our right to scrutinize bills. Mr. Yip. So, Mr. Holden Chow's motion that would the House Committee would rescind the decision made on 12th of April to set up the Bills Committee. And a lot of members have spoken that on the setting up of the Bills Committee is already a question that whether it was set up by the HouseCom since the more than 3 members put up their hand, plus this committee was formed. So, that whether we have the authority to rescind the decision is seriously challenged. First, the President of the House Committee, which is Starley herself to be the gatekeeper, and the member, from what I heard, that he then made a decision, and now that you have been tabled to HouseCom for the members' consideration. When you have so many doubts, I see that we should prudently examine this question instead of rushing into a decision. Mr. Lim Chak Ting, I heard from the legal advisor that 32 with the President's permission that the Council can rescind a decision. That is the Council President. Okay, the legal advisor explained that the rules of the Electoral Council would apply to other Electoral meetings, for example, the House Committee. If so, what's the basis? Can LA explain that after the Bills Committee is set up by the HC, does it have the right to repeal any bills, to dissolve any Bills Committees formed by HC, or if so, which provision? Just now, you just repeated that the chairman arranged a meeting to discuss this as a fact. However, a fact is not a legal opinion. Mr. Wuchiwai? See it from another perspective. In this ruling, there would come someone accede to S4S request to send it directly to council. If the establishment agreed to this, on one hand, you are refusing to acknowledge, to recognize that the bills chaired by James had already been set up, and your previous ruling is just simply incomplete. So, and then you send the bill directly to Electoral. So if not complete, then let it be. So, what is the necessity in dealing with Mr. Chow's motion? If we don't deal with Chow's motion, what is the impact of the proposal sending directly the bill to the Electoral Council? Mr. Chu? So, on the legal advisor quoting of RP 32, first I see that as for whether we have these set up the Bills Committee by the HC, I think 32.2 is more applicable. That if they taken decision and the question decided into a negative, so we haven't ever voted on whether we to set up a Bills Committee. What have we done? Is it a chairman asked which members would like to set up a Bills Committee, and then 3 members put up their hands, and then the committee, the BC is already formed. So it can be regarded that on the scenario under 32.1 that that it was that decided that by actually you have a collective consensus by for this decision. You can't say that out of 77 at a part, RP 76.3, you have 3 rules set up. Then you call that the House had approved the setting up of the BC. That's incorrect. KK Kwok. Well, first my question is an question. If our eventual decision that would disagree with what Mr. John Lee had proposed, would there any difference? Because we said John Lee is disrespectful of Electrical, and not even you yourself, Mr. Lee, that he won't react to anything you've done. And for 32.1 and 2 is clear. If the Bills Committee is already in operation, we have to consult the Bills Committee, and in the BC, including the one with James Ho as the chairman. I know that. Have you ever consulted Mr. James Ho himself? Or rather, you have been appointed transferred to the Bills Committee for discussion. Before we enter today's motion, please have you complete all the procedures. Can you answer my question first? Otherwise, you might forget my question. Mr. Alokin. Well, I will respond after we finish this round. I believe that for Mr. Chu, if from what the HC understand in the process of setting up the HC is set up by 32.1, but 32.0 when actually not a decision, our understanding would be wildly different. Just now, the legal advisor had invoked RP 31 and marked it as 75.4. That simply referred to the committee under 54.4, and for 76.3, one is referred that will there be a membership at least 3 members. So it's have a clear definition on the formation of the Bills Committee. We interpret that on 12th of April we haven't set up the Bills count. Then how can you rescind that decision? We have to have a legal and reasonable and constitutional decision instead of making a decision that might be unconstitutional that will subject to legal challenges. Next, Mr. Dennis Kwok. Just now I heard Mr. Gary Chen ask the Pandem's letter whether we have communicated with the foreign governments. I can say that no, we didn't. We try our best not to. So the answer to the question as can Mr. Chow answered me before he wrote his letter. This is not a point of order because that's your DAB member asked the question. I'm simply respond to his question and ask Mr. Holden Chow that while you read this letter, have you colluded with the government officials, or is it really your own opinion? Just a simple question. Would a member with their own speaking slot? Now we are on point of orders. Next, Mr. Jeremy Tam. The legal advisor, I hope that you can elaborate on that later. On 32.1, that the council take a decision on a specific question and the question decided in the affirmative. That is when it is decided in the affirmative. So does that mean that we have a vote that whether we or not, and whether we form a BC, we're not decided by a vote, but just anyone would need to set up the BC. So isn't that 32.1 is not applicable since it's actually taken a decision? That means you can't invoke 32.1 in approving Mr. Holden Chow's motion to propose to rescind the HC decision. I hope the legal advisor can respond to my point on what do you mean by taken a decision. Or is that a vote took place or where there are no objections? Mr. Alvanier. Mr. Legal advisor have been quoting invoking RP 32.1, and 32.1 actually make it a part G on the motions. Well, this is more a council thing. Even by council rules, you allow that can be drawn reference by HC. But decision to set up BC is based on our House Rules 20. Why 32.1 is target the council motions that can be drawn reference to the decisions made by the HC. So what is the basis? Or you simply invoked wrongly. So what is the basis for that? If we just simply draw some application to receive the case, so I hope the legal advisor can clarify. Ms. Claudia Mo. And also I'd like to ask the legal advisor, when you quote invoke 32.1, on things about the motions, but no. So what is your understanding? I see this is only applicable to the council. So by you invoking it, I'm quite surprised. And it made it clear that has taken a decision. Usually I would interpret as having held a vote. It didn't say quote a vote, however in English has been decided in the affirmative. While raising hand could be seen as affirmative, is that what you plan, that we don't need a vote? My second question is based on House Rule 75, as in referring to the Bills Committee by HC. Was referred to in English, there's no decision process involved. Next, Dr. Helena Wong. I still think that today we should ask these journalists, S4S and CE should attend, especially John Lee. Well, because we're discussing it because he read written to HC, and upon reading his letter, that makes us furious. It says that we're undermining the dignity of Lachiko, but the culprit is John Lee himself. The Apple amendment will been on hold for 20 years, and all of a sudden you table this bill and ask us to pass this bill before summer. If it's not controversial, it might be quick, but now it's controversial. And this Bills Committee is give birth by the HC, and now is the chairman of HC. If you just listen to John Lee, and then you just killed your baby, how many meetings have we held? That's outrageous, and why don't we come here to explain? Third round, Mr. Chu. Let me finish to listen to Mr. Dr. Chung and Ms. Ted Hui, then we finish with this round. Chairman, I noticed that the RP 32 as invoked by the legal advisor is all about the motions. We should fall under Part G, which and but is setting up a BC is a motion? Apparently not, but whether it's a decision, maybe not, because it's not a decision made by the HC. Therefore, whether the BC has been set up, as long as members have proposed it and we have 3 or more members joining the BC, that will be set up. Whether there are right away or afterwards are not important. They had no direct relationship with the House Comp, and so whether the House Comp to set up or make a decision, 32.1 is totally inapplicable. Next, Mr. Tony Paul Shea. Assume that we're already debating the relationship and arrangements between the House Com and the Bills Committee. So it is not about referring the bill to the Bills Committee. Do not need to be touched upon. We don't need to put we had no one question. We can pass this I'd like to learn from the legal advisor how do you interpret 21R of House rules and the Bills Committee will be dissolved as soon as the bill can pass through Council or when the House Committee so decides. House Authority have the authority to cancel. I would see how the legal advisor see this. Dr. Priscilla, I'd like to ask the legal advisor, the RP 7511. The committee may consider in such manner and as things fit for any other item referring to the business of this council.
Consider in such manner as it thinks fit any other item relating to the business.
And now that the situation faced by the HC is previously unseen in my years of member, so we can't elect a chairman is quite unlikely. I hope that the Bills can get onto it. However, a lot of members don't want this bill or this Bills Committee under these unique circumstances. And for 7511 or RP, how did you address this unprecedented circumstances? Mr. Ted Hui, last person.
You are under huge pressure, but still you need to be professional. You need to listen to the voice of your conscience. Just now we referred to ROP 32. Either you're trying to impose a will on us or there is some problem with security. Regarding the logic under Rule 32, is it right for us to draw reference from that? Are you affirming that ROP 32 applies in this case? If you confirm that it applies, then it shouldn't be 32.1. As members have already said, we didn't put the matter to the vote to set up the Bills Committee. In fact, there were 3 members subscribing, and so it should be 32(2) because the question wasn't decided in the affirmative, and therefore we shouldn't query the decision, not to mention rescinding the decision. So please tell us whether ROP 32 applies or not. Before I give the floor to the legal advisor, I accept Mr. Houghton Charles' proposed option. But before I did that, I have read up the rules of procedures. Of course, in the light of the references made today, I would look at it again. Well, when we deal with the bills, in fact, the House Committee plays a very specific role. If you look at 75(4), well, a bill can be referred to a Bills Committee or it can be dealt with under some other ways. According to 75(5), we can decide on the timing as well as the priority. For 75(7), that's about the way that members signify their membership. 75(8), the committee may provide guidelines relating to the procedure of the Bills Committee. The House rules also talk about our functions. Say, for example, the approach to be adopted in scrutinizing a bill. Moreover, the House Committee may decide whether to extend the duration for the consideration of the bill, and you can find it in House Rule 21H. The bill can be shelved so as to allow the next Bills Committee in the queue to start work. And 21(R) also empowers us to dissolve a Bills Committee. In other words, the relationship between the House Com and the Bills Com I think it has been clearly set out in various provisions under the RP and the HR. My understanding of this incident is that at that time we invoked RP 75(4). We made a decision to refer this bill to a committee. Just now members mentioned as to whether as long as 3 members had signified their membership and then the Bills Committee was set up. I had clarified with the Secretariat. In the past, we didn't have that. Now, if a member would like to set up a Bills Committee and we have got 3 members, then we set up the Bills Committee and we start meetings. And that's the tradition, the convention. If it has encountered an objection, and in fact you had come across that, and the matter was put to the vote. But for this fugitives bill, we didn't have any objection, and then we followed the convention and we decided to refer the bill to a Bills Committee. So for ROP 75(4), we decided that it should be referred to a Bills Committee. Since we made that decision, we are also empowered to rescind it. And then under 75(4), we can decide on a manner that we think fit to deal with it. LA. Well, I think during the last round, I already mentioned the relevant provisions. I have 2 simple points to make. For 21G of the House Rules, I think it is clear that is the House Committee will decide whether to set up a Bills Committee. That's 21G of the House Rules. Indeed, the House Committee would decide on whether a Bills Committee is to be set up. As to whether it should be the outcome of putting it to the vote, then it is a second question. It is a separate question. And then for ROP 32(2), it talks about the question being decided in the negative. When that is the scenario, then 32(2) applies.
咁即係話咧，其實當時係會有一個決定，就係
In other words, a decision has been taken and the decision is not to do something. So from this perspective, I cannot see how that a House Committee makes a decision to set up a Bills Committee should be regarded as the scenario under 32(2) of the ROP that is decided in the negative. I think that's clear. We should have the last round of points of order, but then I need to respect the order of members pressing the button to speak. So if you want to speak, please press the button. Mr. Paul Chair, you too. Well, just now many members made a similar point. Legal advisor, do you have anything to add? I think members have said that you haven't. Thank you, Madam Chair. If I may supplement to the point made by Paul Chair, there is House Rules 21R. Indeed, it says that a Bills Committee will be dissolved as soon as the bill it has considered passes through the Council or when the House Committee so decides. So in accordance with this particular rule, the House Committee can make a decision to dissolve a Bills Committee. Well, please be specific about the point you want the LA to answer. Mr. Edichu, well, I think in this round, it is about points of order. So press the button to speak. I think we're all on points of order. Sorry about that. You are in the first round, all right? I'll give the floor to you, Lang Yu Chung. Well, we members have asked the LA questions. He should give an answer immediately. Otherwise, that would be too general, too vague, and he may omit some of the points. For 32, that's about motions that should not apply to House Committee. Is that the case? If you allow this to go on, it is not going to assist in our discussion. So I just wonder if, from now on, after we have asked questions, the LA should give an immediate reply. Otherwise, it is not going to be effective. So please answer this question, Madam Chair. I'll try my best.
如果你唔係咁做嘅話咧，我哋幫助唔到我哋進行討論㗎。
請法律顧問，如果你係議員回應之後，你想回應咧，你可以即時回應。如果你需要準備多啲，
但係如果我哋議員要求佢嘅回答嗰時，可唔可以俾佢回答先呢？
梁美芬議員，
主席，你答咗問題先，可唔可以？主席，
我會盡力去處理。梁美芬議員， 其實我都係想法律
Will he answer this question? If I may refer to 75(11). Now the House Committee gives birth to a Bills Committee. And for 4 times we have not been able to elect a chairman. I did wonder whether we could set up a Bills Committee in as short as a month's time. Please be specific about your question. Yes, I need the LA to answer this question. What is the difficulty that we are facing for 75(11)? I think we do have the discretion. That is, we can come to a decision. That is the approach we think fit, so as to respond to the aspirations of the society. 75(11), of course, that empowers the committee to resort to a manner as it thinks fit, and that's in relation to any other item relating to the business of the council. Well, as I have said, for the House Committee, for the bill we have to deal with, that's in accordance with 75(4). That is, the debate has been adjourned. So we have to decide what's the best way to deal with the bill referred to the House Committee. Ms. Leung, LA, be brief. Exactly. Well, for 75(4), we have to deal with it. One of the ways is to dissolve the Bills Committee. I think this is entirely in line with the rules of procedures. Well, I think at the end of the day, we put the matter to the vote. I think the majority can be empowered to do so. We have the discretion. LA, anything to add? Let me repeat the point. As I have said to Paul Chair, for HR 21R or HR 21R, yes, indeed, the House Committee has the power to dissolve a Bills Committee. Well, I suggest the following. The last round of points of order, I'll also invite the legal advisor to answer. We have had 2 hours meeting already. I would suggest that we have a 10-minute break so that we can have a pause, and then we'll come back, and then we can have a more constructive discussion, and then we can have we can start the debate properly.